A very good morning to all my dear students and listeners. Today we are going to discuss about the drafting of revision petition under the subject captioned as drafting, pleading and convincing. As you all are aware, the said topic is being given under unit number 2 of the university syllabus. But before starting with the drafting of the said revision petition, I just want to recapitulate the law relating to revision petition, which is provided under section 115 of the Code of Civil Procedure. So my dear students and listeners, let's go through the law on the same. The relevant provision for filing a revision petition is given under section 115 of the Code of Civil Procedure 1908. At the outset, I just want to apprise you that the word revision has not been defined under the Code of Civil Procedure. My dear students, as you all are aware that various words and expressions has been defined under the section 2 of the Code of Civil Procedure, such as judgment, decree, order, pleader, government pleader, foreign court, foreign judgment, so on and so forth. But the legislature, while enacting this legislation relating to Code of Civil Procedure, did not define the word revision. As such, to define the said word, that is the revision, we have to look into the various meaning provided under various law dictionary. As such, as per dictionary meaning, the word revision means to revise, to look again and to go through carefully and correct where necessary, meaning thereby the action of revising, especially critical or careful examination or perusal with a view to correcting or improving. Under the revision petition, the petition would lie to the High Court, unlike the Code of Criminal Procedure, wherein the revision petition under the CRPC would be filed or would lie before either the Session Court or the High Court concerned, or under section 397 CRPC and 401 CRPC. Under section 115 IPC, it empowers a High Court to entertain a revision in any case decided by a subordinate court. In certain circumstances, this jurisdiction is known as revisional jurisdiction of the High Court. So from this, my dear students, it is clear that For the purpose of drafting a revision petition, one must be clear in mind that a revision petition would only lie to the High Court, and that must be a decision given by or decision pronounced by a subordinate court to that of High Court. Next. Now I would like to apprise you the nature and scope of revision petition or the revision provision under section 115. Section 115 CPC authorizes the High Court to satisfy itself on three matters. Number one, that the order of the subordinate court is within the jurisdiction. Second, that the case is one in which the court ought to exercise its jurisdiction. Number three, that in exercising jurisdiction, the court has not illegally, by committing some error of procedure in the course of said trial, which is material in that it may have affected the ultimate decision of the case. So these are the circumstances or the points to be looked into by a law student or by a lawyer while drafting the revision petition. Further, in the case of Major S.S. Khanna versus Brigadier F.J. Dhillon, wherein the court has stated that the section 115 consists of two parts. First, prescribes the condition in which the jurisdiction of the High Court arises. That is, there is a case decided by a subordinate court in which no appeal lies to the High Court. And the second set out the circumstances in which no appeal lies to the High Court. The second out the circumstances in which the jurisdiction may be exercised. So from the above said, we may infer that revision under section 115 of the CPC acts as a source for the High Courts to supervise the subordinate court. The term revision implies examination with intent to improve or correct. Thus, the High Court may correct any illegality or irregularity or impropriety. The revisional powers of the High Court may be invoked upon the application or suo motu. So from this, we may infer that an application for revision can be invoked only on the basis of the application of either of the party or of any aggrieved party or suo motu as well. Here suo motu means court of its own motion. If it thinks fit that some illegality has been committed by lower court, then court may also rectify the same under section 115 of the CPC. Further, section 115 of the CPC lays down the principle of revision. It says that the High Court may call for the record of any case which has been decided by any court subordinate to High Court and in which no appeal lies thereto, and if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed to exercise a jurisdiction so vested, and the number three, that is to have acted in the exercise of its jurisdiction illegally or with material irregularity. On doing so, the High Court may make such order in the case as it thinks fit, but it shall not vary or reverse any order made or any order deciding an issue in the course of the suit or other proceedings. unless the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings, or the order, if allowed to stand, would occasion a failure of justice or cause irreparable injury to the party against whom it was made. The High Court under Section 115 of the CPC shall not vary or reverse any decree or order against which an appeal lies, either to the High Court or to any court subordinate thereto. The expression any case which has been decided includes any order made or any order deciding an issue in the course of the suit or other proceedings. If a court tries a suit for which it has no jurisdiction to try, having regard to its limit or local limits or pecuniary limits or subject matter, it is an exercise of the jurisdiction not vested in it by law. Likewise, where a court has jurisdiction to entertain a suit, to execute a decree, or to review its judgment, but refuses to do so on the ground that it has no jurisdiction, it is a case of failure to exercise jurisdiction vested in it by law. Similarly, it is an illegality or a material irregularity in the exercise of jurisdiction vested in a court if it passes a decree on an unstamped promissory note or an order against a person without hearing him at all. Next, what is the object behind filing of revision petition? It is to prevent subordinate courts from acting arbitrarily, capriciously, and illegally or irregularly in the exercise of their jurisdiction. It clothes the High Court with the power to see the proceedings of the subordinate court are conducted in accordance with law, within the bounds of their jurisdiction and in the furtherance of justice. So these are the conditions which must be kept in mind, my dear students. Please keep in mind all these conditions while drafting a revision petition. And number one, a case must have been decided by the lower court, and the court which has decided the case must be a court subordinate to the High Court. Further, the order should not be appealable one, meaning thereby no revision lie in case appeal lies. The subordinate court must have exercised a jurisdiction not when vested in it by law. Number two, there must be a failure to exercise jurisdiction vested in it by law. And the last ground for invoking the jurisdiction for revision is acted in the exercise of its jurisdiction illegally or with material irregularity. What is the form of revision? Meaning thereby, is there any format for drafting a revision petition? Answer, no particular format of revision in the court has been given. Such petition, however, must contain the grounds as to error of jurisdiction covered by Section 115 of the CPC. So my dear students, while drafting a revision petition, please keep in mind that no format has been prescribed, but the grounds relating to errors of jurisdiction as contemplated under Section 115 must be put or must be there while drafting a revision petition. Is there any limitation for filing a revision petition? The period of limitation for preferring a revision application is 90 days from the decree or order sought to be revised. Further, Revision is not a continuation of suit, but it is altogether a separate proceeding. Therefore, to file the petition for revision, a fresh wakalatnama would be necessary to enable the advocate for doing the needful. The revision would not be maintainable when there would be no failure of justice, nor would be put to an irreparable loss or injury as contemplated by Clause B of exceptions to proviso to Section 115 of the CPC. The High Court can exercise power of revision suo motu or on the application of an aggrieved party. Under Section 115 of the CPC, the High Court can also exercise under Article 227 of the Constitution the power of superintendence over all courts and tribunal within its territorial jurisdiction. So from this, we may infer that there is an interrelation between Section 115 of the CPC and Article 227 of the Constitution of India. So this is all about today's lecture, my dear students. But before parting with today's topic, I just want to apprise you with my new topic, which I am going to take in my next class or next lecture. And my next lecture would be on review petition. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay healthy, and stay safe. In case you are having any query with regard to today's topic, then you may revert it to me by writing an email, and my email ID is rahularoda.gn@jagannath.org. Thank you very much. Okay.